Hi, everybody. Thank you so much for joining us. We are in our second week of the Managing Farm Risk webinar series. And with us today, we have Kyle Mandeville. Kyle is an attorney at Mandeville Law, his own practice, and he's going to be talking about legal risk and legal matters with us today. Take it away, Kyle.
Very good. Thank you, Renee. Hope all is well out there. It's morning here in central Indiana. So whenever you're viewing this or get a time to, we'll say good morning, afternoon, evening. But it's a pleasure to be here. Thank you for the opportunity, Renee and team. And I hope everyone learns a bit or two and doesn't fall asleep in this 55-minute event. Today, I chose three topics that I see that come up on a regular basis with, I would say, farm families, farm operations. And probably not in the order of importance. I think number two, we started with types of entities. That's always a hot button topic with farm families. Contracts, I'd say to me, that's not a question folks ask, but it's a high risk area that it should be discussed. And then probably most important is estate planning. So those are the topics of the day. I would ask any questions that you have, please post them to the chat board, and Renee will field them, and then I will do my best to address them at the end. So let's get on with it. So a little bit about myself here. I'm a Purdue Ag Econ graduate. Let's say a few years ago, I was there in the Krannert building, and then I also went down to IU for a law degree. So I sit on both sides of the fence on those old open bucket games, but I can't lose is my version of that. I've had an honor and pleasure of being in the ag law industry here, well, going on 20 years now, and mostly, it's really throughout Indiana. I have clients who reach from the northeast corner all the way down to the southeast corner of Indiana and all the way between. So it's an honor to help, and I learn something every day, and hopefully protect and I help my clients succeed in their ag practices. So personally, I've been raised in a farming community all my life. We live in that. I'm not a farmer. There's some folks that want to be a farmer and an attorney, and that's nothing against them, but I've chosen to choose one track and do it well, do it with everything you have, and keep it at that. Don't get me wrong, surrounded by farm matters at all times. Actually, my law practice is based out of our farmstead here in the Attica area, and we're surrounded by many acres of family organic row crop operation here. So just last night around 11:30, the chopper pulled out over the 60 acres north of our house after getting the hay cut. Thankfully, the rain didn't come this morning, so they'll be at it here momentarily. We do. My family does own farmland and treats that as an investment. But as I said, we are not farmers. I don't do that day in, day out, but I understand the commitment and happy to help neighbors when they need. But if they want to take their tractor under, let's say, potential damage by somebody that doesn't know how to run a tractor. From an ag law perspective, I do about everything. I can help the farmer buy the 40 acres next door, get a purchase agreement together, get it to closing, but I can also help the $500 million farm operation with entity structure, succession planning, tax strategy with an accountant, and on and on and on. So that's a very wide range of ag law experience. And tucked in there is a lot of real estate, a lot of business, a lot of estate planning, a lot of solar, wind energy lease reviews, and on and on and on. So I stay busy and enjoy it, and it's an honor to be here today. So thank you. Thanks to the North Central Extension Risk Management Education grant, we are sitting here today, and I hope you learn a little bit, and we'll go with it from there. Couldn't have a presentation or a document without an attorney disclaimer. So, of course, I used an entire slide for this, but short version is There's no personal advice involved here. If you need actual advice for your situation, your tax question, see your attorney, see your accountant, call me for a private confidential conversation. Please don't disclose confidential issues in the chat box and the questions that will go in. And then I'm only licensed in Indiana, unfortunately. So I conduct all of my business in Indiana. And for those folks located right on the Illinois line, on the wrong side, as I would say, the high tax side, sorry, I can't help with Illinois matters, but when you want to buy your Indiana farm, call me. So, okay, today, let's start with entities. To me, that's a hot topic for risk aversion, and let's dive into that. Usually, I'll have clients who say, Kyle, when I get sued, I don't want to lose everything. Set me up with the right corporation, with the right LLC. And it used to be when I was a young attorney, maybe a little hungrier, I'd whip out a quick LLC and have the operating agreement, buy-sell agreement ready to sign. Now, I tend to explore what the client's risks are, what their operations like, what their long-term plan is for ownership and next generation, incorporating them into the business, and come up with a strategy that might include an entity and might not. So, the wise advisors out there won't spin out an entity. They will, they're going to take it. They'll go, frankly, a little slow and get the information, pull in maybe an accountant or another consultant's advice, and come up with a plan. So that's my general approach. I know we're talking entities here, so that tends to lead to the fact that you should use an entity for risk aversion, risk limitation. But start with the question: do you even need or should you use one? For instance, what type of industry are you? I'm presuming you're ag, but let's say you have a little fresh cut flower business, and you sell them on the roadside, or you take them into the local grocery. What's your risk there? Is someone gonna die because they sneeze of pollen? Possibly, but is that your issue? Isn't that just a general theme of the flower industry? Now, maybe you're selling beef on a roadside stand. That I could see. You have a disease, or the meat's not processed appropriately. I could see using an entity to reduce your risk. On the flip side, is there insurance that can remove or transfer that risk to somebody else? And are those premiums reasonable? I know using the term insurance and reasonable in the same sentence is an oxymoron, but if you can insure the risk away, you might consider not using an entity. What type of bookkeeper are you? Well, for some folks, it's the shoebox at the end of the year and dropping it off of your accountant and asking them to prepare your tax return. There are other folks who keep detailed records, have their journals, track everything in QuickBooks, and frankly don't mind having another set of books for an entity. Well, if you're that type of person, you might want to consider an entity. And then ask your accountant, ask your attorney, ask your farm consultant if you need an entity. Be careful though, because generally their advice is yes. And why is that? First, they're not willing to take a chance. If you do get sued and you do lose everything, and they told you not to use an entity, guess whose fault that might be? And second, if they're hungry and looking for business, they would probably like to prepare another set of books and a tax return for an entity. So, take it with a grain of salt. So first of all, start with whether you should use an entity. I'm just going to kind of dash through some of these entities that we have here today. General partnership, very simple. You want to start a long care business. You and your partner next, or you and your high school buddy next door, Attica, lawn care, guess what? You don't need any agreement. You just start out. But what happens when your first customer writes a check to Attica Lawn Care? Well, you're not going to be able to cash it because nobody has that name. So that will require, at least in Indiana, that you record this certificate, a DBA certificate, that then formally recognizes that you two, the partner, and you are this partnership. Then you can open a checking account in the name of Attica Lawn Care, sign checks, and pay expenses and take in income. Guess what, though? The partnership, you have no liability protection. So it's as if you're operating on your own. Good news, bad news. A limited partnership is similar. However, for the limited partners, and you need to get an agreement to define that, they should have liability protection. But there are general partners in a limited partnership that do not have liability protection. You're asking, why in the world would we use a partnership if there's no liability protection? We'll get to that. All right. Most common types of entities would be a limited liability company. Those are frankly very flexible. Indiana, they don't require as much information disclosure, don't require annual meetings or minutes, but you should have, I would say, the minimum in place: operating agreement, buy-sell agreement if there's more than one owner, and you can go into a plethora of tax planning if you need to. One nice thing that an LLC has, and I've seen more and more clients use, is the single member LLC. That means there's one owner. And because of that, the IRS will allow the LLC to file its taxes, declare its income, and deductible expenses on your personal tax return. You don't have to file a separate tax return. So that's a relatively new tax option. I wink because I think it's going on 15 plus years now, probably 20. But it's a interesting option. It does have a little less liability protection, so you frankly get what you pay for. But it's a simple man's approach to this LLC. You've got other tax strategies that can be used. You see this castle picture in the slide. The reason I put that there is this is a good option for building an asset or a nest egg, putting it in and protecting. You're trying to protect your wealth and put a moat around it. I could also use the bucket. You're trying to protect assets by putting it in a limited liability. So if you have a high risk business and it's in a limited liability company, if everything's done right, the liability should stay within the company. On the other hand, if you have a large amount of, forget large, 40 acre, $18,000 an acre farm, and you have a high risk business, you're going to want to separate those. So maybe you have two LLCs, real estate LLC and a high risk business LLC. That way, one of them gets sued. You're not subjecting the other asset to risk. The other type of entity that's normal is a corporation. I'm just going to touch on that here very slightly, and that requires more disclosure. There's more functions to that, formalities, because it's been around much longer, and you have to comply. That's one, at least in Indiana. You need to have annual meetings, minutes. You need to be documenting. If you're not, see your attorney, see your accountant. Those need to be documented because you do have liability exposure if you're not going there. Entities. Why in the world am I bringing up insurance? Well, your entity still needs insurance. Don't let your liability insurance lapse. Don't stop paying your premiums. Have insurance, have appropriate insurance. Your insurance is going to provide for attorney cost defense. It's going to provide for, frankly, many other benefits, but it's going to do way more than your LLC should. However, insurance is no guarantee, and we know contracts, and there are attorneys out there that like to avoid insurance policies all the time. So the combination of a well-insured and a well-documented and followed entity is a potent combination. However, let's flip this. Like I said earlier, you might be able to use insurance if it's a good policy to avoid using an entity. So that's an option. I've heard it 5 times, I've heard it 100. After a client meets with me, we form, let's say their LLC, we get it all up and running, all the partners sign off, the real estate's contributed, cash has been deposited into the new LLC account, they have a checkbook, and then the client asks me the infamous question, is it time for me to cancel my insurance? And I look at them and say, is that why we formed this LLC? No way. Keep it. You're not going to save on your insurance premiums with a new entity. Just get over it, move on. Farm planning with entities. Be very careful. Use somebody that actually knows what they're doing. That's the short version. And as I was working with a past FSA agent here, I think it was 2 weeks ago, he'd been an FSA agent for 17 years. Now he's a consultant. And as he said, I just learned something today. So even the folks with long-term experience in the government agencies and offices don't know. So be careful who you ask, get it in writing. Don't rely on anything that a government agent would tell you. You need to get it from somebody that you're paying so that you have unbiased advice. So just that's my summary. It'll change. Those farm programs change, so do the entities. But note, we were talking earlier about general partnerships and limited partnerships. This is a reason why, frankly, many of my clients use general partnerships. It's for FSA planning, farm payment limitations. However, there's no liability protection. So you're not going to get your cake and eat it too if you're getting paid by the government. Very time sensitive. In the last 3 weeks, I've been working on some strong, hard June 1st deadlines on this type of FSA planning. So it is crucial that your ducks are in order. And this is a strict liability issue. If you don't comply, you lose your farm payments. So you gotta know what you're doing, who you're working with. See somebody that you trust and that knows what they're doing in this area. General entity comments. Frankly, don't overdo it. Match your personality with the type of entity. As I say there, match your risk tolerance. I have folks who can't sleep at night if they think that they're going to lose $100 because they don't have everything sheltered. Well, guess what? Those type of people have an entity for each farm that they own. Pretty cumbersome when you come into tax reporting, documents and accounting it throughout the year, but that's what they want to do. Others buy that $3 million liability insurance policy and an umbrella, don't use any entities and move it forward. They don't, they look at risk and rush right into it. So your entity plan needs to match it. Little points of caution. I would avoid using these, what I call the Russian nesting doll entity plan. It's where you have entity after entity after entity and trying to build liability moat protection around each one. At some point, you're gonna lose track of what the plan is and how it works, and then your liability protection goes out the door. Why is that? Because if you're not following your own governing documents in these entities, the court's not going to uphold the protection. So, and then the old keep it simple smarty. The older I get, the simpler it should be. And I hope I'm still pretty young, but there are reasons to have many entities, but I would say that they're becoming fewer as I get older. And hopefully that's the same for you. Topic number 2, contracts. Why in the world did I bring up contracts? Well, because I see this as a major risk source for the farming operations, farm owners, farm families. Nobody stops, takes the time to read, forwards the document on to their attorney, their accountant for a review. It's just a matter of signing it and moving on. Let's check the box. I got 800 things I got to do today and time for 500. I need this. This needs to be done. Well, what I've noticed in my, with my farm operators, with my farm business owners, the folks that pay attention to details,
they are the ones that are doing really good. They catch it, they do it. They don't take the default answer, default agreement. They put in the extra time it takes to negotiate. So you might be successful without looking at. You might stay out of trouble. If you're a quick talker, maybe the agreements won't come back to bite, but at some point they could. And so slowing down for a bit and looking at these documents is wise. Actually read the agreement is what I ask. As an attorney, of course, I'm going to say that, but I have a couple of clients, maybe I should admit that I know don't read anything. They don't read what I prepare. They don't read what the other attorney prepares for their signature. They just move forward. And that's talk about risk tolerance. That's on the incredibly high end. So read before you sign, because a handshake just isn't what it is. I'd love to say, take everybody's word for it and strike your $1 million deal with a handshake and get to the closing table. Unfortunately, I have quite a number of lawsuits I've been in because the agreement didn't match what the parties intended, or there's a lot of verbal agreements outside the written contract that somebody wanted. And that's not how it works. If the agreement says that all verbal comments are struck, then you need to know that going in. Read your document. And why are we talking about contracts? Because if you're putting it in writing, you're limiting your risk. You're going through an exercise where two people have to review and come to an agreement that this is what's going on. That this is where this is what they're agreeing to. That sounds probably a little corny, but I have so many folks say, "Well, no, this was the agreement." I have this is what I heard, and it was just 2 days ago. My teenage son was buying his first car, and he put out verbally an offer. What he said was $11,050 for a new car, which that's amazing how car prices have increased compared to my first new car. And the other guy heard $11,500. So now we have a difference of $450. Well, we had to put it in writing in a bill of sale to address that, and we got that out before we went down to the BMV and signed the title. Just the little things. Add a couple zeros after that, and all of a sudden we now have a reason to litigate and be in court for years. So that's why we have agreements. General matters about contracts. You need to know who's involved, who are the parties. And I know that just sounds so extraordinarily simple, but not really. Let's say you have, let's say you're signing a seed contract. And they put your individual name down there and sign. Well, guess what? You just signed up personal liability to pay for that seed contract. Even though you have a farming LLC that you're running your business through, you should have signed as the general manager of the LLC. That way, you personally don't have liability. Or you didn't read it, and there's a clause, I've seen these before, where it says, anybody signing this contract is agreeing to personally be liable. So I'm an employee. I'm a $15 an hour salesman for this multi-billion-dollar corporation, and I sign one of the vendor contracts that has this clause in it. Well, guess what? Billionaire corporation goes belly up. If they really thought I had some money, they technically could sue me under that contract for unpaid funds if there's a balance of it. It sounds highly unlikely, but it's incredible what's written in these contracts. There's a lot of one-sided contracts out there. If there are entities involved, make sure you have the proper entities. Say that farming LLC that the farmer owned, he should be signing the seed contract under that entity, not his real estate holding company, not his trust, not his management corporation that he formed for his health insurance plan. It needs to be the appropriate entity. Where is the money flowing. That's how I describe and try to figure out what the right entity is. Follow the money. Where is it coming out of, and where is it going? And with that, you can usually define what type of entity is. Now, if you do have an entity involved, you got to track down what it is, who's involved, what the name of it is, and it's actually in operation. Going back here, this Secretary of State website is a good source of information. Here this morning, I pulled up ABC Coach Lines Incorporated, just random entity. If this company wanted to sign a contract, and if I'm involved, I'm going to go look them up. And guess what? Oh, they're administratively dissolved since July 16th, 1996. They're not even effective. It's not an entity. And if they would sign something, it would be worthless. However, let's say they are in full compliance and they're opening. Well, now who should sign for them? Well, here it looks like James Loser and Elaine Loser, president and secretary of the corporation, should be signing. Or at least that's what I would expect. If they put somebody else up there to sign, I would ask for corporate documentation to prove who has authority. You need to know who's signing. And then you also need to confirm the name. If they put it down as ABC Bus Driving Incorporated, well, that's not this entity name. So it needs to be precise. So that's a little random. When you have information, or you might go check your own entity's information on this site. Make sure it's current. Make sure you have that you're not administratively dissolved. All that means is you fail to file the annual or biannual reports, and 90 days have passed, I believe. I could be wrong off on that, and they've administratively dissolved you. So that's not a good thing, by the way. General matters. Read your contract. If it's too broad, if it's one-sided, don't agree to it. Move on. There's more important things to do. Signatures require everyone to sign. I had a client buying a piece of property, and the purchase agreement was given to me to review, and it was a standard realtor broker's purchase agreement, so I wasn't that concerned. But I looked at it. Okay, well, I was about ready to give my check mark. Yeah, this is okay. And then I go, let me go look and see who owns this real estate. So I did. Went to public records and found, like, oh, there's 3 owners here, and we only have 1 signature on this purchase agreement from the seller. So we went back to the broker and said, hey, we don't have a binding agreement. We need all 3 owners to sign, and they did. And then we knew we had a binding agreement, especially in this appreciating real estate market. I want to know that we're going to get to the closing table, and we're going to close without the seller renegotiating because of some small technical detail. So that's my 2 cents or real life example. Word of caution on these signatures: please read the friggin' document. I'm amazed by how folks, you'll send a 15-page contract by e-signature, and literally 3 seconds later they signed and it's returned to you. Folks are not reading the documents that are being sent for e-signature. Please read them. As your potential future attorney, get the document reviewed and review it minimally yourself. And then always ask for a fully signed copy. If you're in the middle of court litigation, that's not the time to ask the other side for a copy of your signed contract. You need to have one housed in your records. Types of contracts: farm lease. If it's more than 3 years, see your attorney. It probably needs to be recorded. Purchase agreement. Other assets, real estate. These have to be in writing to be binding. You've got to go through it. It's tough to show up at a title company and say, I want to close on my $3 million farm without a purchase agreement. They're going to ask you details. Who's paying for taxes? How are you splitting the closing fee? Who gets possession? And on and on and on. So it's got to be in writing. Solar and wind energy leases and options. Those obviously, will probably outlive the folks that are negotiating them. They're 50 to 100 pages. Those need to be taken serious. Easements, those need to be in writing. They need to be creatively negotiated, not just the standard form that the title company suggests. I had a client here a few days back who was willing to allow a third party to have an easement over their property. They had one simple request. No semi-trucks are allowed across their property. So we had to somehow define the easement. So the back and forth of a vehicle going through was only residential vehicles, no semis, no heavy commercial trucks. So now, more importantly, how is that going to be enforced? Well, that's another day, another person, but we'll make sure the document's there and recorded. Maintenance is a big deal. When I've noticed on easements, 50 years from now, when the entire farm lane is bottomed out and muddy, who gets to pay the 15 grand of rock delivery and landscape fabric, I should say construction fabric, that's put down to recreate the lane? Don't know if the agreements doesn't say it. Sure, it'd be nice if you had a couple sentences to address that issue. Other agreements that I've run across in my farming client experience, grain marketing agreements, big deal. I've been in major lawsuits where the farmer didn't agree with the consultants or the marketing hedge group. When we're talking millions and tens, if not in hundreds of millions of dollars, and if there's a mistake or two, these grain marketing agreements are huge. So make sure you read them, make sure you negotiate them. Production contracts, if you're producing seed for Bex or for some other seed company, make sure it's in writing. It's what your premiums you're getting paid, when you're getting paid, the quality that you have to provide as a farmer. Product liability, that kind of goes back to the roadside stands. If you're doing a farm to table, you're providing meat or vegetables, probably you're not going to have a contract when you're selling on the roadside stand, but you're providing it to the local grocery. It might be nice to have something in writing that limits your liability. Employment agreements, huge deal. If you have employees, you need to have well documented what they can't do. I'm not saying that that's going to control them, but at least legally, you have an option. If they go out and take pictures of your hog barn, post it on social media, make it look the worst ever, even though you take pristine care of the hogs and the building, you need to have something where you can immediately go to court, shut down that social media site, and stop the distribution of it. Don't get me wrong, legal process takes a while, but you need options. And then at a minimum, you need the ability to fire them, frankly, yesterday if something like that happens. And then most important, I say that facetiously, but not really, prenuptial agreements. Why, if you do or if you don't agree morally with a prenuptial agreement, totally get it. I'm probably personally right on the fence there. Think of the farm, think of the generations coming before you. You can always start with a prenuptial agreement, but it has to be signed well before the wedding. And you can always give in once the spouse or future spouse proves his or herself. But don't try to do it afterwards. Or it could be like a farm family that I have worked with. Bride's dad said, we have to have a prenup. We're going to prenup, Kyle, draft it, get it done. And I said, yeah, no problem. We pushed like heck. We got everything in writing and documented. And part of the process is you have to disclose your fair market worth and your potential inheritance that you might receive from your family. So the bride put everything down. We got that. Great. We're at the signing table. We attach, the personal net worth of the bride, and the groom attaches his. We look down. Well, the groom has a couple more zeros after his net worth statement than the bride. So essentially, dad of the bride had disinherited his daughter from the groom's inheritance by pushing for a prenuptial agreement. But hey, details. We win some, we lose some, but at least their farm is protected. General terms, I'm just going to go through this quickly. Consideration, what's being paid. Question to the audience, put this in the chat box. What if there's no consideration in contract? What happens to that contract? deadlines are deadlines. If you see time is of the essence in a contract, that means there's no wiggle room. If it says June 1st closing and you don't close, you're a loser, depending on who you are. You've breached the contract, you now have to pay. Venue and jurisdiction, watch these on these boilerplate contracts. You'll see them all over. Delaware, New York, Michigan, South Dakota. That's where you have to go if you want to enforce the term agreement. So do you want to hire a Delaware attorney? That's usually how I ask. That's what I ask my clients. Jury waiver, depends on who you are. If you're the one providing the service or providing the product, yeah, you do want a jury trial waiver. You don't want to have to go to jury trial and defend it because your beef had some type of disease in it. But on the flip side, if you're the one sick, or if you had a daughter who got really sick from a product, yeah, it'd be nice to be in front of a jury and claim all the damages that you can. And attorney fees, you got to have a provision in there that fees and costs are recouped by the breaching party, or the one that failed to live up to the terms of the contract. If not, you essentially have a toothless agreement, is what my basic review is. General comments on contracts. Everything's negotiable. You got to ask. If it's a Delaware venue, push back. Say no, it's Indiana. You're coming to me for business. I'm paying you. That's all happening in Indiana. We're going to Indiana court. We're not going to Delaware. If you do make revisions, this is like pencil on the farm signature. Make sure they're initialed. Make sure they're initialed by someone's authority, not the $15 an hour salesman who's just dying to get that $500 commission. He'll initial anything. Needs to be the president. Needs to be a manager of the company. Slow down before you e-sign. Please just slow down. Print it out. Take a night. Review in the morning before you e-sign. Use your common sense. That's my kind of summary of contracts. All right, third topic. Hope I haven't worn you out. You're not dozing here with that contract topic. We'll wake you up a little bit here with estate planning. Estate planning. The most basic estate planning plan is, how do you own your assets? Are they in an LLC? Are they jointly owned with your wife, so that if you pass away, your wife automatically owns it? You have all your kids on your bank accounts, so when you die, they each get their share. By the way, you can see my bullet point there. I'd avoid that. That seems super simple and a quick, efficient way to transfer. But guess what? If even if your kids do get along, you could have forced them into a partnership by transferring assets, undivided interest to them. That's something you need to really be careful of. Estate plan documents need to dovetail with your entity documents. If say your real estate farm LLC says only family members by lineal descendants can own your LLC units or shares, like your will says you give all those LLC units to the church, we've got a problem. Maybe not. Maybe we sell the units to the family and the church gets the money. But if the will says the LLC units go to the church, then that testator, the person that signed and drafted the will, for some reason he wanted the church to own the LLC, and it's not gonna play out very well. So it's gotta be comprehensive on your review and your planning. Fair does not mean equal, especially for farm operations. I hear that hundreds of times. The on-farm heir who's worked hard, worked the 18, 20 hours a day, but yet doesn't have health insurance, not getting a salary, compared to the off-farm heir who's getting a $150,000 salary at how about this, a Cush corporation in the big city. They might not get the equal inheritance. So hey, it's up to the family. Communication is key, but communication sometimes needs to be done correctly, if not always. And sometimes correct communication is no communication. So I'm not one to say communicate everything. You have to be very, very strange, or you have to be very careful. All right, you do have an estate plan. Even if you're sitting there, you've never signed a document in your life, Now, I've had umpteen folks come into my office and say, Kyle, I don't want the government to get a cent of my hard-earned money. Don't let it go to them. And I said, well, I think we can do that. Unless you screw up whatever I prepare, we can definitely do that. Why do I say you already have a plan? Well, here's a general order and priority of transfers at death. First, if you've put assets, say your house, in a trust, you transfer that before death. So whatever your trust says, if it says my house is to go to my daughter at my death, then after death, the trustee is going to sign a deed transferring the house to your daughter. That happened, frankly, before you died. The trust was in place and you had retitled the house real estate title. Second, by operation of state property law. What if that house was jointly owned with rights of survivorship with your daughter? Well, guess what? Immediately at your death, your daughter can go down to the recorder's office and execute and record an affidavit, and she's the 100% owner of that house. No questions asked. And there might be 5 hot, mad, spitting siblings who thought that they should have a 1/6 of the house, but the deed didn't say that. The deed said joint tenants with rights of survivorship. Third, contract. Life insurance beneficiaries, retirement plan beneficiaries, prenuptials, bank account records, bank account agreements, those all control. So that those are estate planning mechanisms. Fourth, your will. Well, guess what? That is extraordinarily low on the priority list. Your will says, my $500,000 bond account down at Edward Jones is to go to my son. Guess what? When you set up that Edward Jones account back in 1995, you stated that it was supposed to be split between your 3 kids, and you named them as beneficiaries. Guess what trumps Edward Jones account? Because it's in priority-wise, it's 3rd in line, and your will is 4th. That's where we get to have some nice discussions, if not some court litigation, to prove what Dad's intent was, and if there was undue influence. Not fun. So this is where you got to review legal documents as well as account ownership and real estate ownership, title deeds. There's a lot going on there. And last but not least is the government by intestacy law. So if you don't have a will, you don't have a trust, your state has given you an estate plan. And if you don't act before your death, that is your estate plan. So if you're in Indiana, this is your plan until you've signed a will or a trust. And these on the left-hand side is your relatives who are alive and what's the status of your marriage or second marriage. And then on the right is who receives what. Pretty straightforward. If you have children and you don't have a spouse, so you're the second to die spouse, guess what? Your children inherit all your assets. It seems fair. But the library that you wanted to receive a $10,000 bequest to your death doesn't get anything because the state of Indiana doesn't care about charities. They're not going to put that in. However, say you are still married and your children are with your current spouse. Well, guess what? Your children have won the lottery. They get half of your wealth. Your spouse gets half of your wealth as well. That's not what I normally hear. On the first to die spouse, we want half of our wealth to go to our kids, a little premature inheritance. No, it's usually, I want everything to be kept together to take care of the second to die spouse. I want all the income and all the assets to protect and lead to a good life for the second spouse, the second to die spouse. But if you're relying on the state of Indiana, guess what? Those kids are happy. And and your wife, not so happy. Here's another interesting. What if you have multiple marriages? So the 4th line down there, you're married, second spouse, their second marriage and you have children from the first marriage, whoo, dicey. Your spouse gets half your personal property. Furniture, household goods, all that stuff. So half the couch goes to the kids, half the oven goes to the kids. I'm being facetious, but that's, this is what we got to go through. We got to value everything and split it up. Oh, and then spouse gets a quarter of your real estate. So the 500 acres that sit out back, they own 25% of that, among some miscellaneous claims that they can file in an estate. But the children are the real winners on this second marriage situation. Probably not good, probably. But what if you die with nobody? You don't have, you're that uncle, recluse uncle who lives in the cabin in the woods. You'd outlived everybody. And for some reason, you're the last to die. No family members or descendants whatsoever. Now, who's the winner? Here we are, state of Indiana. The Attorney General's office will be happy to accept a check from the estate of your uncle. And all the farmland will be sold. All assets will be reduced to cash, and the state of Indiana is the winner. So I know I'm being facetious, but look down here. I mean, you've got 6, 7, 8 levels you got to go through before the state of Indiana is going to get you your assets. So that's far-fetched, but don't let my conversation be the reason for delaying getting a will or a trust. So a little reality planning here. What's a will? It's a simple document to effect your wishes after death. You need to name somebody that has fiduciary duties, the personal representative in Indiana that will carry out your wishes. You're saying who gets what. You don't have to change any deeds or title during life. You can revoke your will. You can have amendments, which are codicils, every other month to your wills. It's a private document while you're alive, but the kicker is it will be filed in court and everybody will see what you provided for in the probate process. And if you have changes, they're going to see the amendments. It could get a little hairy. So that's not usually a positive, but on the other hand, it's simple. So you got to weigh the confidentiality versus the simplicity of a will. Trust is a trust is an alternative to a will. It can be very detailed and provide for after death wishes, but it does require additional efforts. You got to make sure you funded the trust. So that 500-acre farm, you need to sign a deed that transfers from the recluse uncle's name into his trust. That way, after his death, the successor trustee will control the farm. It is confidential. That's the big deal right there. Shouldn't be filed in court unless there's a nice fight. Otherwise, it's a private document. The successor trustee should follow the records with that. Many different types of trusts, you name them. You can create irrevocable trusts for tax strategy or for life insurance purposes. Testamentary trust is a contingent trust that's in your will. So say you die prematurely, you've got 3 children under the age of 10. Well, guess what? In that situation, you do need a trust. It needs to hold. Both mom and dad have passed. You need a trust to hold the assets, take care of the 3 kids. But you didn't really want to create the trust at the time that you were living and going through your estate plan because there's no need. So you essentially, a testamentary trust means if there's a need, it'll spring to life, it'll hold the assets, and it'll provide for the 3 kids in this situation. Dynasty trusts, those are I guess common in high net worth families who want to keep their assets together for many, many generations. You got to be careful where you create those and kind of the details, like all the deeds on the dynasty trust. So see a professional if you're going that way. Don't try to do it yourself. Advanced directives, frankly, just as important as your will or your trust. Power of attorney, make sure you choose someone you actually trust. That is huge. If you're an agent, be careful though. There's huge liability. You need to keep your records in Indiana for at least 6 years. And if you screw up, you have high personal liability for wasting money, losing money, misinvestment, maybe it's not even your fault. Question I ask clients is, how many times are you going to use your power of attorney? Many times during your lifetime, especially at your end of your lifetime. How many times are you going to use your will? Make sure you choose wisely on your agent for your power of attorney. Healthcare, you need to name a representative for making decisions if you're incompetent or unable to. If you want to make some advanced decisions on healthcare at the point of or near death, living will and do not resuscitate declaration can do the same. If you're a planner, you also want to put your funeral wishes in writing. The state of Indiana has an excellent route for you to do that as well. General estate plan comments, it's got to match personality. You like complicated, do you like simple? Guess what? There's both. You can do what you want. My infamous client question, do I have to order new checks? After he created a trust and had just ordered new personal checks from his checking account, he did not want to spend the $35 to get new checks titled in his trust account. So we had to come up with another solution. After spending many thousands of dollars on his trust and real estate transfers, that $35 bank fee was just not acceptable. But hey, it's one of those. Once again, keep it simple and communicate. However, if the plan is not acceptable, let's say you're disinheriting your 3 kids and you're giving everything to your newly married spouse that's 40 years younger than you, probably don't want to communicate that. Might want to just let your attorney or somebody else communicate that after you're gone. And you might want to go through a whole bunch of other planning options to keep that. So acceptable is in quotes, whatever that means. So be careful. All right, enough of my droning on here for 53 minutes. If any questions or have come in, I might have possible answers. So let me know.
Feel free to drop your questions in the chat and we can throw those out to Kyle to get you guys some answers.
Yeah, I bored them, did I, Renee? I got to wake them up.
I don't think so. I'm sure they're just typing right now. I don't see any burning questions from anybody yet. We'll give everybody a couple more minutes just to be sure.
Yeah, that's okay.
Well, I'll kind of remind folks, if you've not had a chance to see the other webinars, there's quite a number of them. You can register at this website. I think this is the legal one is the second one, and there's been one presented. There'll be many more coming. So if you haven't fallen asleep by the legal rambling here, I'm sure there'll be much more lively presenters in the future. So this is a nice way to earn a producer certificate and add one more thing to your resume.
And we had someone say, thanks for the information. I don't think it looks like anybody's got questions right now. So thank you so much, Kyle, for your time and for presenting. Thank you, everybody, for joining us. And we'll hope to see you next week. I think we're talking about production risk.
Okay.
All right.
Very good. Thank you, Irene. Appreciate it, Ed. All the help. Have a great day, guys.